Good afternoon, everyone, and welcome to another episode of the Future of European Law from the Master 1 of the Catholic University of Lille. Today we will talk about extradition with Chloé. Hello, Chloé.
Hello.
Could you tell us about the extradition in EU?
Well, EU is not foreign to the extradition because it created in 1957 the European Convention on Extradition, which entered into force in 1960. Mm-hmm. And extradition is a process that allows a state to deliver the offer of an offense to a foreign country to be tried there or carry out a sentence. So this was the case in the Marco Kamenisch affair of 2002, where a Swiss man was extradited from Italy for assassination. The Convention is also open to non-member states, and the European Convention on Extradition cannot be detached from the Treaty of Rome, which was signed in the same year, because the principle of non-discrimination, which is enshrined in Article 14 of the Treaty of Rome, can be an obstacle for extradition. Mm-hmm. In the judgment we are going to present, named SM versus Generalstaatsanwaltschaft of 2022, it is about the discrimination about the notion of a national.
Okay, so tell me more about the context of this case.
So it's very brief. The applicant is a Serbian, Bosnian, and Croatian national, and he has been living in Germany since 2017. On November 5, 2020, Bosnia-Herzegovina requested his extradition to serve a prison sentence due to corruption offenses committed in Bosnia-Herzegovina.
So how was this decision of extradition taken into account for human rights?
Well, firstly, the public prosecutor of Munich requested the extradition refusal based on the Roger Vicius judgment, which the question asked to the court at the time was if Article 18 and 29 of the TFEU could be interpreted to mean that they prohibit the extradition of a union citizen despite the extradition obligation under international treaties. And there was analysis of human rights in this affair. But the problem was there was different in circumstances because in Roger Vicius, extradition was about a citizen with Finnish nationality who could benefit from provision in Finnish law which prevent his extradition to a third country. And here, the problem is that the applicant is not a German national and thus cannot benefit from the protection against extradition given by German law. So, in the field of human rights, the EU places special importance on respecting the human rights of individuals. It also created the Charter of Fundamental Rights of the EU, and it asserts the principle of non-discrimination, which prohibits the discrimination based on nationality regarding the application of treaty. So the member states have a positive obligation which prohibits any inhuman and degrading treatment within its territory. And the problem about extradition is that there is a risk for the individual to face inhuman treatment or acts of torture, death penalty, etc. And this was the case in a recent case in September 2023 in Compaoré versus France or contre France. And the question was that the French authorities didn't take into account the new political context in Burkina Faso, which influenced the chance of risk of inhuman treatment. Also, the court, in our case, in its solution, applied the Petrovian doctrine, which was born after the Petrovian case, and it established a specific mechanism for the extradition of a national of a member state to a third country. This mechanism is triggered when the state to which the request is addressed applies the nationality exception only to its own nationals, which may lead to discrimination, as we talked earlier, between the national of that state and the national of other states who have exercised their right to free movement according to Article 21, paragraph 1 of the TFEU. And this mechanism was also applied in the Roger Vicious case in 2018. And more recently in 2020, in BY versus Generalstaatsanwaltschaft, which was about the extradition of a Romanian national for the purpose of enforcing a criminal penalty. In our case, the applicant, I recall, is a Croatian national, and thus he must benefit from his right to free movement, which accorded to him a certain level of protection against extradition. And the court asserts his right in its decision, and we can argue that it's a more considered decision taken in consideration of human rights. However, it restricts the principle of the free movement and residence within the EU.
Okay, thank you very much for this explanation. Now, I would like to know, how does this solution demonstrate the presence of EU criminal law?
Well, it's the second aspect of the decision, because at first sight, you can think that the court's decision here is discriminatory, because the applicant doesn't benefit from the protection of German law despite living in Germany. And so the court decided to rely on the principle of European criminal law. So extradition may be permitted to enforce a sentence, and consequently there is restriction to freedoms, and that must be justified, of course. It is based on objective and proportionate considerations to the legitimate objective pursued. This is a fundamental principle governing European criminal law. And in the EU, criminal law is manifested by the cooperation between member states for the judicial domain. So you have especially legislative acts which can be adopted to facilitate this cooperation, and they act as complements of international treaties. So legislative acts can restrict the fundamental rights if the measures taken pursue a legitimate aim. Extradition to a third country has been made possible, by the way, to enforce a sentence with the Convention on the Transfer of Sentenced Persons, and especially in Article 2, which, I quote, "A person sentenced in the territory of a party may be transferred to the territory of another party in accordance with the provision of this convention in order to serve the sentence imposed on him. To that end, he may express his interest to the sentencing state or to the administering state in being transferred under this convention." And the court, in its solution, decided to base its solution, on the legitimate objective of preventing the impunity of convicted individuals, which was the case for the applicant. And it demonstrated the existence of a genuine legal framework for European criminal law in the EU.
All right, so do you think the court values the respect of the treaty through this decision?
Yes, I think it's its main basis, because the sentence of the applicant can be executed in Germany, in Bosnia, if Bosnia-Herzegovina consents to it. And Germany would disregard its obligation of extradition to which each member state is subject under the European Convention on Extradition. So you can see that in this decision, the protection against extradition for nationals of member states is not guaranteed, not by either the treaties or the court. Indeed, member states define the terms national in the European Convention on Extradition. So some member states provide protection against the extradition of their national to third country, or to the territory of another requesting state, which can be another member state. And there was about it a priority question of constitutionality in 2014. In France, it is, for example, formally prohibited to extradite a person holding French nationality, even if the individual consents to it. Thus, a member state is not obliged to provide the same protection against extradition for their national and for national of other member states. So, if a citizen does not possess the nationality of his member state, in our case of Germany, he can be the subject of extradition. And if the extradition is possible, there is an obligation of information from the requesting state, because the member state which needs to extradite the national must make sure that there is no risk of inhuman or degrading treatment. So the court also choose to prioritize the obligation for Germany to extradite the applicant to Bosnia-Herzegovina, because the member state to which the extradition request is addressed has the right to investigate whether there is an alternative means to execute the sentence without the need to extradite the national. And this is the first part of the answer of the court about this question. And in case the state making the extradition request does not give its consent, the member state must surrender the national at the risk of violating its extradition obligations. So, there is a convention on the simplified extradition procedure among the member states, which was created in 1995. And it has facilitated the execution of extradition requests, particularly in the criminal domain. And this has been decided in the context of this cooperation, of the judicial cooperation that I mentioned earlier. And that it also added that the potentially disproportionate nature of the sentence cannot be an obstacle to the mandatory extradition following a European arrest warrant. So the court lifts, so we can see that in this decision, the court lifts the protection granted by German law, since this applicant is not a German national. And it also acknowledges the necessity to explore the option of executing the sentence within the territory of the member state, of course with the consent of the first state that requested the extradition. But you can also see that the court doesn't rule out the possibility of extradition if the requesting state doesn't give its consent. So thus, Germany must extradite the applicant. Also, the court decides to prioritize the respect for the European Convention on Extradition and the obligation of member states to extradite, and this can be explained by the fact that the court privileged a desire for international peace with the respect of international obligation from international treaties.
Well, Chloé, thank you very much for this insight on extradition. It was very interesting, and I wish you a very good afternoon.
Thank you.